We get that informal agreement, and then we do a mediated settlement. We turn that into a mediated settlement agreement. We pay a mediator to turn it into a mediated settlement agreement.
A drive-by.
A drive-by, yeah, or drive-through. Drive-by? I don't think.
Ooh, I think drive-through.
Yeah, I think drive-through is probably better.
Sorry.
Just straight gangster over there.
Tequila, sorry.
Welcome back, guys, to Cases and Cocktails. I'm Bryan Eggleston, and my beautiful wife, Janice Eggleston, here with me again. How are you doing today?
Good. How you doing?
Doing fantastic. Today, guys, we're talking a little bit about navigating child custody cases here in the great state of Texas and really sort of how you, different avenues in order to get your case done. Today, we've got a very special cocktail, though.
Yep. So
this is my favorite cocktail right now.
right now. So for episode 11, we did a tequila old-fashioned. We used Cascades reposado. There's chocolate and orange bitters, orange peel, and one of those fancy cherries. Oh,
Yeah.
and some brown sugar.
Oh, man,
Sweeten it up.
it's my absolute favorite. You don't like tequila?
I do. I just, this drink is just booze with a little flavor added in, so it's a little strong.
It is by far my fave. So here you go.
Good though.
You don't want yours, let me know,
Mm.
and I'll drink it for
okay.
you. Probably in the middle of this episode. I'm all right with that.
Thanks.
Yeah, I'm offering. It's the least I can do today.
So kind.
I do what I do. All right, talking about navigating child custody divorces or child custody cases and divorces. And honestly, there are two ways in the great state of Texas to finalize a child custody case or divorce, right?
You can either come to an agreement or you can go to court. And we can't force the other side to come to terms or have reasonable expectations. Can't force the other side to believe in your version. Ultimately, hopefully, everyone sees that coming to an agreement is best for everyone involved, especially the kids.
Yeah.
But if you can't come to an agreement, the only other tool that I have is to take you to court, litigate it, and let a judge make a decision. Or a jury.
Or a jury, or an arbitrator, right? So then you do it that way too. We have said, we started back in 2011, 10, 11?
Mm-hmm.
My God, we've been doing it forever. We've always said this, and I think it's something that is important that our clients hear, but I think more importantly, I think it's important for parents to hear. We believe, truthfully, me and you, it's best when two parents can reach an agreement for the sake of their kids. Right?
Absolutely. You want, there's stuff in the Texas Family Code, and there's stuff based on case law, rules and parameters that the court has to stay within, or even a jury has to stay within. And certain things are presumed to be best for the kiddos. But once I had children, it definitely verified that they're all different. Every family dynamic is different. And if there's any way for the parents or whoever's taking care of these kids to come together, put their differences aside, and make those decisions without court intervention, that's always the best way to go.
That's and I'm just going to say it, that's sort of a really fucking stupid idea, though, when you have two people who are holding themselves out in public, literally saying, we don't get along and we can't figure it out, so we hired lawyers and we want you, judge, to figure it out for us.
Well, and I think that people have a misconception about how often cases end up in litigation, right? Most divorces, most child custody cases happen and are resolved without lawyers involved at all. It is rare that you have attorneys involved. Obviously, it's what we do all day, every day, so it doesn't feel rare, or like the one-offs. But when you've got, generally speaking, if both parties are going to hire lawyers, then you've either got a divorce case where you've got high asset values, or you've got high conflict cases as far as custody is concerned.
No, and the other thing is, first of all, you're right. You're right that, there's a reason people hired lawyers. And the reason I said it was sort of silly is because, or a silly concept or proposition that the two parties, it's best that they'll agree, but they're obviously holding themselves out. You want them to agree, but it has to be an agreement between the two parties, and it can't be an agreement between the attorneys, the families, Facebook, whoever. The parties have to reach that agreement. If they can't reach the agreement, then the only other way to do it is to litigate it, whether it's in court, right, from a judge, a jury, or an arbitrator, right? Those are the only ways to do it. And so, when you talk about navigating this, those are the two avenues. And what we do here, right, we kind of walk that path parallel, right, simultaneously, concurrently, right? We're trying to get information so we can help you resolve your case amicably, right, by agreement. But at the same time, we're getting the same data, the same information, and trying to use it to determine what our position is in litigation.
We're trying to make sure our cases are always litigation ready because that could happen at any turn. It could seem like the two of you are coming to an agreement, so you're never going to need to go to court. And it's always those cases that in the middle of them, they blow up. And, one side is amending pleadings, setting hearings, and the other side just seems to be blown away and shocked. But if your team, your attorney, is always ready for litigation, then you're ahead of the game. The other thing too is, it's all fine and well to try to come to agreements, but if I don't know everything that I would need to know if I were to go into court, I can't negotiate a fair settlement for
Right.
you because I don't
Right.
know everything.
Right.
You can tell me or the other side can tell me this is fair and this is all that we have, but if I've not done the legwork, I can't tell you if that's a just and fair division of the estate. I can't tell you if, what we need to firm up or, what our best litigation strategy is going to be.
Yeah. It's, that's the thing too. Like, and I think people oftentimes, or not oftentimes, sometimes think, we'll just we'll go to mediation and we'll get this resolved. And respectfully, there are some attorneys that just kind of show up
Walk
to
into mediation
right,
without any numbers, anything.
right, and haven't really talked to their client about expectations. And
Right.
so, I don't want to get too far off into the specifics, but for us, we approach mediation like we approach it like we're going to court or a hearing. We prep our clients. We talk about possible outcomes, but more importantly, we talk about possible sort of solutions. That way, one, they've heard it. We get immediate feedback, whether it's a visceral emotional reaction of hate,
And
right?
they can process whatever those emotional reactions are, hopefully,
right,
or at least start to address them before mediation, so
Right.
that when they go into mediation and they're making decisions that are going to impact the next few, at least years of their life,
right,
generally speaking, more than that, they can be prepared for that and start
Right.
focusing on that and not just then hear about the stuff that's going to make
Right.
them have an emotional reaction.
And in order to properly prepare them, you got to have all the information, all the data,
Yeah,
right?
the
So,
data.
so we do all the work, the prep work and stuff to go to mediation. And most of the time, right, that helps us, one, in our room, go through the day with our client in a much easier and much more pleasant environment, right? There's not these wild emotions and these swings, and it's not managing a lot of those things. But more importantly, we're prepared. We knew kind of what we expected. And we can navigate the different sort of offers or positions that are taken during that day. Lends itself to hopefully being successful and getting it done. A lot of work goes into that, but I think the clients ultimately win, right? It's a win for them, right? They're not stressed. They're not making, having to make these, sort of snap, reaction, reactive sort of,
They don't have you and the mediator staring at them, asking them a question that they've never heard before, never contemplated before, and have to give you an answer, so they can send it over to the other room, right? Like they've been prepared for it
right.
for the
Oftentimes,
most part.
right. Oftentimes, I don't know. I'm sure you do the same thing. I tell my clients all the time, like, okay, well, here's, the mediator's going to come over and talk to us,
Mhm.
and we'll tell them exactly what we've already discussed, and here's where we're at, and then they're going to go over there to the other room. They're going to be there for a while,
For a
and
while.
it's just going to be us.
Mhm.
So, That's part of it. Mediation, just real fast too. Mediation is a thing where most counties are going to require it
Before going to trial, sure.
before going to final trial. You can go to mediation for temporary orders. You can go to mediation for singular issues. You can go to mediation for the whole thing, right?
Mhm.
Um, just real fast to a mediated settlement agreement, irrevocable. Don't want to get into all the details, but it's irrevocable. Once it's filed, it's done. Very, very difficult to undo.
It
Very
is
difficult.
pretty much ironclad.
All right. Um, a lot of very limited certain circumstances where you could undo that, and they are minimal at
Yes.
best. That's an agreement. Once you reach that agreement, it's in place, it's in effect. There's going to be a final order that gets drafted, final order or decree that gets drafted, and then that's what the parties submit to the court, and the court signs, and that's what the parties follow. So there's a little bit of work, but ultimately, as we said, two parties can come together to reach an agreement for their kids. It's best for their kids. It
It's
really
a
is.
lot less time, effort. Um, it's generally a lot less of a financial burden, right? Going to trial is super expensive. And when you go to mediation, or try to settle a case. You might tell your attorney or the mediator all the terrible things about the other side, and then you've got to filter for how that gets relayed to the other side. And sometimes all of that information doesn't have to go over there. When you go to trial, it's no holds bar. And you're throwing mud back and forth. Everyone's saying the worst of the worst things in a public forum where anyone can be in there, watching what's going on or get the report for it later. Um, it, generally speaking, will help any potential that you two are going to be able to co-parent in the future if you don't go do that in court.
Yeah. It's, mediation it's a space too, which is really nice, where not only do you don't have to say all the bad things. The nice part about mediation too is um, it's all confidential. So you can go into mediation and you can, contemplate certain things that you would never contemplate, right? Certain outcomes you would never contemplate at final trial, or take different positions that you wouldn't take. So it's all confidential. Um, and it's a good space. I tell my clients all the time, I'm like, mediation, you can say no. Just say no. You don't have to agree to anything. But just know that, the other option here is to go to court, right? Whether it's, judge, jury, or arbitrator, you're going to litigate this.
You're putting these decisions in a stranger or
Right. So
several strangers'
there's
hands.
right.
Yeah.
Something else to do. I want to talk real fast just about a mediator. Mediators are typically, not always, but typically they are family law experienced lawyers, judges, um, and there are certain mediators that are better for certain situations. There are
Mhm.
certain mediators that aren't good. They're just, and I don't mean that. They're just, there's different approaches, and so that's something that you need to contemplate as well. If you got a really complicated, property division, you want a mediator,
International
right?
property, whatever it might
Right.
be. You want a mediator that's
E-
experienced in those things so you can
exactly.
make sure nothing falls through the cracks.
Right.
And part of a good mediator's job is giving reasonable expectations in a room, right? I think it's great to use people that are retired, but if they're so far removed from actual litigation that they don't have their finger on the pulse of the courthouse, then it's hard to give the parties reasonable expectations. Part of a good mediator's job is coming in a room, hearing what someone wants and saying, that's fine. But when the other side rejects it, it's because you're never going to get that in this courtroom. And you need to understand that. That is extremely helpful, in my opinion, to getting the parties to actually come to the table and start to fairly negotiate.
Right. Yeah. I've, there are certain, reasons why you want different types of mediators, depending on your client, depending on the other side, depending on the facts. Um, yeah, the worst is when you just have a mediator who just goes back and forth and is just passing offers back and forth.
The courier.
Yeah, the courier, right? It's just not helpful. also, but you also don't want someone who's going to come in and tell your client, look, you go to court, you're going to lose, da 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 da,
You're
and
wrong, right?
giving your client legal advice. And so there's a balance. There's a balance there, but that's important. I think it's important, having the right mediator, being prepared, going to do the things, and then more importantly than anything else, letting your client have an opportunity to work through the emotions of what those offers are and what they could be, and,
Mhm.
and that sort of stuff, and what those expectations are. Because again, you can do it. Just as a quick note too, I got to do this real fast because I was just thinking about this. Um, I had a case one time. It was a kid case, so it's a custody case, and it was fairly high conflict. And we went to mediation, and we did mediation in person. We don't do a lot of in-person mediations now,
So
right?
so pre-COVID.
Yeah, this is pre-COVID, so but it still applies. I still tell my clients every time we do mediation. Um, we went to the mediator's office, got prepared, did the things, drove all the way down there, and when I got there, the mediator um, walks up to me and says, "Your client's here." And I said, "Well, that's great. That's awesome, right? That's half the battle, right? GI Joe and all the good stuff." And she says, and she brought the 2-year-old
Oh,
to mediation. And
you don't think you have to tell
I
them
didn't
that's
I
not
didn't think I had to
okay?
say it,
Yeah.
right? And I'll be honest, it's the reason I say it now every time. And I'll never forget too, like the mediator and I were standing there talking to my client, explaining why
This is not okay.
this is not going to work. And the client is sort of not fully comprehending that. And the 2-year-old is climbing all over the mediator's like office furniture and desk, and it's sort of generally just everywhere. We're like, this is why this is not going to work. Anyway, so children shouldn't go to mediation. How about that?
I think that's fair.
It's not a thing. So anyway, mediation is one way to do it. You don't have to go to mediation. You can also informally settle these things.
Mhm.
You do the same thing without going to mediation.
You can have
Uh,
settlement conferences, offers sent back and forth between the attorneys. You can even come together as a team at someone's office and try to work through it. I think generally speaking, it is more efficient to have everyone come together though and commit the time to sitting down and working on this one case, because what ultimately will happen is one party will send over an offer. We send that to the client. We then review it, schedule a call or a meeting with the client. Then we send something back over to the other side. They're on vacation. Months have passed and we're nowhere closer to a settlement than we were before. Now, facts have changed, feelings have happened, and we're 13 steps behind where we were when we started. So, there is something I think important about dedicating the time, space, and effort towards that particular case.
right. No, it creates a sense of everyone's there to do the things, and a little bit of pressure, right,
Mhm.
to get it done. This happens a lot too at the courthouse. Like
Oh, yeah.
you get prepared for a hearing or a trial, and you go and
It's always the
yeah,
cases you really wanna have heard,
oh
though,
yeah,
and then they come to an agreement right before.
yeah, and you can go do it. One of the things I want to talk about just real fast too. A lot of times, we'll get an informal agreement, and we get that informal agreement, and then we do a mediated settlement. We turn that into a mediated settlement agreement. We pay
Mhm.
a mediator to turn it into a mediated settlement agreement,
A drive-by.
a drive by, yeah, or drive by. I drive by. I don't
Ooh,
think.
I think
Ooh, yeah, I
drive-through.
think drive through is probably better. You
Sorry.
just straight gangster over there.
Tequila, sorry.
Oh. So I think you do that. It just makes it irrevocable. You can't go back. I did one time in the courthouse.
Mhm.
We had an agreement in the courthouse, did the things.
Went and grabbed an attorney that
I grabbed
mediates
a
and said
colleague, right?
mhm.
He mediates. I said, I need you to, mediate this right now, right? And sign this. So we did. All right. Well, let's talk a little bit, I guess. If you don't resolve it amicably,
Mhm.
right, then you got 3 options. Bench trial, right, which trial in front of a judge.
Mhm.
Um, a jury trial.
If you have jury
They've
issues.
got jury issues, and then you can arbitrate.
Mhm.
Um, all of them have different benefits, detriments, all the good stuff. But and without really going into all the specifics of all three, I think we could do that for hours. This is really where this is litigation.
Right. This is going in front of someone
Right.
and
Presenting your
your
case.
case,
Yeah.
opening arguments, putting on witnesses, testimony, evidence, and ultimately leaving the decision making to someone else.
Right. And it's, you know, that's what we do. I think for us, when we approach cases, like you said, we do it concurrently, right? Simultaneously of, settlement and litigation at the same time. So if settlement doesn't work, we can't get an agreement, then we can flip over to litigation and advance forward and do it that way. And it's a lot of work. It's a lot of work to take the totality of someone's life
hmm
um, and put it take all these different pieces of information, these data points, accusations, and
Concerns,
concerns,
wishes.
and put them all into a presentation and make it coherent. And really what we're trying to do is put our best foot forward for the client in whatever capacity, right?
And
Judge,
it's hard.
jury, or arbitrator, right?
It's hard because as a litigator that there are certain things that have to be presented.
Right.
And then the clients have certain things that they want presented or they want heard. They want to feel like their story is being told. And that's an important part of being an advocate. But you've got, it's hard sometimes, but you've got to tailor your presentation and make sure that you're putting on what needs to be put on so that you can get what you want out of it being, the end result. I want primary of the kiddo. I want 75% of the community estate,
Right.
whatever it is.
Right.
There's certain stuff you have to prove.
75.
75.
Nice. All right.
Go big or go home.
Ooh. I agree. No, I agree. I have, you see it a lot in high conflict. You see it a lot in high conflict. You see a lot of high conflict, particularly in child custody cases where, you know, each side is making these accusations.
Mm-hmm.
And I bring it up because, it's a thing where very rarely do you walk into court and everyone's like, oh, yeah, my ex is a great mom and she's a great person, a great co-parent, right? And she does everything right. And,
But you do have those
you
hearings.
do.
And when you
do.
do, or at least when I do, I tell the judge,
Oh, yeah.
Judge, this is going to be a hard case. This isn't a case where we've got someone that has committed family violence, where there are addiction issues, mental health issues. We've got none of that here. We've got two good parents that just can't agree on issues regarding the kids or who should make those decisions. And I think those are the harder cases for me as a litigator, because I'm just going in and literally saying two good parents, but they can't agree on terms of this child custody order, and it's hard.
Yeah, I did one recently. I did the exact thing. I told them up front, you're not going to hear, and I use the words, the term, sexy, and it's probably not appropriate, but that's the term I use, right? You don't have the sexy stuff to talk about, and those do make it hard. But I tell you, I think when you have the accusations, it's also hard to get the clients to understand that it's not about refuting all those accusations.
Oh yeah,
Right.
people get hyper focused on, okay, uh, you know, the other side, they're making all these accusations every day on the co-parenting app, on Our Family Wizard or on App Close. They're messaging and putting forth this narrative, and it's a false narrative, and there's false allegations, and you see your client spending all their time and effort trying to disprove a lie. Well,
Right.
you can't do that anyway in and of itself, right? And it's important to make sure that your narrative is being documented and presented, but you don't want to hyper focus on proving that you weren't 10 minutes late to the exchange or you didn't ignore the other side when they were giving you information about a parent teacher conference, whatever it is. That if there's an allegation being made, make sure that you've got your narrative, you're doing the things you need to do. But if there's an allegation, that it's the other side's burden to prove that.
Right. It is, and it's about presentation, one. Two, it's about, telling the client, look, hey, they're going to say bad things. That's their job. And when you're at that space of litigation, like you said, we're not talking about mediation. We're not doing the things. And in those, other than those rare instances where you have two great parents, most of the time you're going to go in there and say, this is what the other side did or didn't do wrong, or, did wrong or, didn't do, and it was wrong because they didn't do it. And, that's their job. And they need to, the client needs to understand. And we do, I think I do, my team, I think is a better way to say it, does a really good job of helping the client understand that those things are going to be said.
And the longer
Right.
you're involved with litigation with that particular client, the more confidence hopefully they're going to gain in you and your advice and your
Sure.
guidance.
But the idea is that they understand that those things are going to be said, and it's also okay that they get said and they don't get refuted. Because at the end of the day, just because they said, you're a terrible mom, I don't need to prove that you're not a terrible mom.
I don't need to spend half of my presentation time disproving a lie.
Right.
There are other metrics that I need to meet in order to get what you're asking for.
And so that's an important piece, I think, in talking about the litigation part, right? Talking about the litigation part. You go to litigation, it's the same type of thing where we got to know all the things. We got to know all the stuff. We need all the data. We need to know the information. We need to know the perspectives. We need to know all the things in order to be able to go do it. That is a enormous amount of work that goes into preparing those cases and presenting those cases. And ultimately, when you go into court, whether it's in front of a judge, in front of a jury, or in front of an arbitrator, you're putting on that case, that presentation, and that's it. That's all you get. There's there is no, hey, afterwards let me submit a whole bunch of evidence that we didn't talk about, or here's a letter, right? I want to write to the judge and tell them, oh yeah, here's a couple more things. This is it. You get one shot at it. And one of the things that, as a litigator, this, sometimes we're told you get like 30 minutes, you get an hour, you get 2 hours, whatever the number is. It's limited amount of time. Here it is. Go do it.
And there's no rules that say, there's no rules, there's no case law that says that, you're entitled to at least X number of minutes or X number of hours for these particular issues or this type of a hearing. It's completely up to the judge.
Yeah. And so, that's all of this plays into that presentation part and does the things. For me, I've had cases where you think you're going to be there for day and a half, 2 days, and you get there and you're getting half a day. I've been in there and where you think certain things are really, really important. You've got witnesses, you've got presentation, you got testimony, you got evidence, and the court says, I don't think it's that important today. And you got to just take it and set it aside and marshal through it. And that's why I talk about, you got to be able, it's not just going in on one or two things. You got to have the entire thing ready, prepared, and be prepared for anything that happens. And so those are the ways to do it. If you go to court with a judge, a jury, and even an arbitrator, at some point that person's going to make a decision. They're going to issue a ruling or a report or an award, I guess, if it's arbitration. And ultimately, that's it. That's what you got. There are some remedies afterwards, reconsideration, motions for new trial, appeals, and all these things. I don't want to get into all that, but that person makes a decision, and that's what happens.
That is the ruling. That is the order.
Right. And you walk away, and you may not like it. You may like it.
Usually, if no one likes it, it's probably a pretty good ruling.
Probably pretty decent. And so sometimes this can take forever, by the way. Sometimes you might get a ruling right then.
That is something, too, that I've learned that the general public doesn't understand. You go to court, you have a hearing. Most people expect the judge at the end of it to say, okay, thank you, everyone, for being here. This is the order of the court. Especially at final hearings, it is more common for the judge to say, thank you. There's a lot here to take into consideration. I want to make sure I read through all the evidence that was entered and read my notes and carefully and thoughtfully make a ruling. 13 months go by, you get a ruling that they had missed half of the things you need a ruling on, and
It
I digress.
it is. It's important. I think it's important to talk about that and set those expectations. It is very helpful when and not just for the clients, and I guess you call me narcissistic. Maybe Sandra would tell me I'm using that term wrong. But it's helpful for me too, right? I want the finality. How did we do? Did we win? Did we lose? Did we get what we wanted? Did we not get what we wanted? Right? The
Oh, we
things,
live in a
right?
time of immediate
Gratification,
gratification, right?
right?
I do
Yeah,
something,
yeah.
tell me how I did.
Tell me
Tell me I did
now,
well.
right? Yeah. So, and there's, that happens. But like you said, it is very commonplace to not get a ruling
We call it
for
taking it under
advisement.
advisement.
Yeah. And when you are in that space, you don't want to poke the bear. I've got a whole spiel about that. I won't get into that, but the whole thing is that, at the end of the day, you got to wait until that ruling comes out, and it is what it is. I will tell you this. I know too that, Robert Garza is, working on legislation right now
Mhm.
to, to address that issue. To try to get a faster turnaround on some of that. And so that's something to look at as well. I think it'd be helpful. I don't know. Do you think that? I mean, I don't think you can limit it. I don't think you can say it's got to be within 24 hours, right? But
Right.
in
You
some
do want,
capacity, right,
sometimes transcripts
right,
or, things get entered that are hundreds or thousands of pages,
right.
and the judge's responsibility is to know what's in those documents and go through and read it. You talk about Robert Garza and whether I think, what he's doing is helpful. I see him personally as one of the most selfless people I've ever met. He's gone through so much and advocates for change, and that change will happen, and he won't even let it benefit him personally so that it can benefit the masses. It's just such a pure heart. I love it.
No, it's great too. We had him on previously on Cases and Cocktails, and I'll be honest with you. I still amazed that he did what he did, um, with the time taken, legislation. And so this round, and talking about getting the courts to put a ruling in within a certain time period, I think it'd be helpful. I think it's I think it's something that people deal with, having your child's, knowing your parental rights, knowing the amount of time you get to spend with your child, and having all that in limbo, right, is a really, as a litigator, it's a terrible feeling. I couldn't even imagine as a litigant.
And,
Uh,
I said it and it probably sounded like I was being flippant about waiting 13 months, but that happens. I
yeah,
mean,
I
we're
mean, it
not
happens.
talking about people
Right,
waiting a week or two.
right,
We're talking about people waiting months or years
yeah,
for a ruling from the court. And your option is to sit patiently or wait,
right,
or bug the court and remind them, hey, can you give
right,
me a ruling? Hey, can you give
yeah,
me a ruling? Hey, yeah,
right.
here's your
Ruling,
ruling.
right. So, um, I'll say this: those are the ways to navigate a child custody or divorce case in Texas.
Mhm.
That's it. So many nuances, so many different things, whether it's professionals that can be involved, child custody evaluators, different things. Don't have time today to talk about all that.
Mhm.
Let's do a couple questions.
Okay.
Are you hiding my drink?
A
Your
little bit. I
drink?
saw you
Okay.
getting almost finished, and I
Okay.
was
All
worried you were
right.
going to take more.
Okay. I'm still going to take it. All right. We'll do questions. I'll go first.
You want to ask first or answer
I don't care.
first?
Your world. I live in it.
Okay. You ready?
Yeah. Go on.
What does a child custody evaluator do,
Mm.
and why are they necessary?
I'll make short work of this. Child custody evaluator is someone that is appointed. They have to meet certain qualifications through the Texas Family Code, and they basically go and talk to both parties, interview collaterals, interview the kids, do the things, and they make recommendations as to conservatorship and possession access. Hypothetically, they are the only individuals that are supposed to be able to do that inside of
To make those
to make
recommendations.
those recommendations. Um, they have to follow certain, um, they have to have certain qualifications, and there are certain requirements that they have to do before they can give their report,
Hmm.
that sort of stuff. The court doesn't have to follow their recommendations. It's simply a recommendation, and there's a lot that goes into that. If you are using a child custody evaluator, you better, um, have someone on your side that understands how that works and how to best present your case to the child custody evaluator as well.
Hmm.
Um, So that person comes back and says, you should be primary, or the kid should live with you primarily, or you should only have supervised visitation. It affects you a lot. So child custody evaluator. There you go.
Perfect.
Nailed it.
Okay.
How effective is mediation for resolving custody disputes? I want to do it differently. How often do you think you go to mediation?
I go to mediation for most cases that are high conflict. It's not the norm to have a case where both parties are hiring attorneys and you just settle without some type of intervention, whether
Right.
that being a mediator or court intervention. So most cases end up going to mediation because most courts require that before you go to trial. I can tell you that pre-COVID, my rates for settling cases in mediation were higher because I think there's something about everyone being in the same building,
Right.
and the added pressure of that will, and really too, it's not just the pressure, it's just recognizing how important this is and everyone sitting in a professional environment,
Right.
and taking the time out of all the other things in your day. Um, to come to an agreement. So my rate of success for settling cases at mediation was higher pre-COVID. Now a lot of our mediations are virtual. There's obviously benefits to that, right? You don't have to pay the attorney for travel time. You don't have to sit in a car and commute back and
Right.
forth. Um, you can sit in the comfort of your own home, take breaks, do what you need to do. But there's something about people being at their house and looking at a computer screen that isn't the same.
Yeah.
Um, so we mediate often, right, and of course too, depending on the economy and the time of year and
Right.
other outside influences, that obviously impacts the settlement rate.
Right.
But more of my cases settle at mediation than don't.
Yeah.
The percentage I'm not sure of, but
No, I agree. I think mediation, obviously it's prevalent in what we do. I think it's helpful. I think it's a great space for people to resolve their issues and not have a judge, have to make those decisions for you. Um, I think the success rate oftentimes comes down to having very reasonable expectations.
and you only have control of half of
Half of
those,
it. Yeah, that's
right?
exactly right. I only have control of half of it. And so if the other side doesn't, then to hell with the rest of it, right? Because it doesn't matter, right? So,
Nothing
um,
like filing a jury demand in the middle of
oh
mediation.
yeah, 100%, right? So I know you got another question. I got another question, but I don't want to do that. I want to do something different here real fast. Um, you got a case.
Mhm.
Do you think you should go to mediation sooner or later in the case? Just curious.
Depends on how much information your client has provided you and how much information the opposing party has provided their client.
Right,
You can't go and successfully mediate a case without having certain data points.
right. Do you like going to mediation for temporary orders?
I like going to court for temporary orders and for people to have a better understanding of what that looks and feels like, so that they don't want to go do that again. And not to be ugly about it and to scare them, but that's temporary orders. That is a temporary situation. Going to court is scary. It is costly. It is time consuming. It is stressful. And you don't know what you're going to get at the end of the day. You can go in and have the facts and you can have the law on your side, and you can lose because a judge has a predisposition or a belief about something, heard something, smelled something, and this is the ruling you get. And they have a lot of the D word. They have a lot
Right,
of discretion.
right. Yeah, they do. Last one that I have for you. Um, if you could have it anyway,
Mhm.
bench trial, jury trial, arbitration.
Jury trial. For me personally,
Right.
not the client.
No, yeah. Not for
The
the
client
client.
is
Yeah,
the most
yeah.
expensive, most stressful thing, but
It
jury
is.
trial is like the Super Bowl of lawyering.
Right. Yeah. No, I agree. It's a good time. All right. Let's do that for today. You want to?
Absolutely.
I'm out of drink anyway, so I gotta go. Let's do this. Guys, thank you so much for hanging out with us today. We greatly appreciate it. That's Cases and Cocktails for this episode, and we look forward to seeing you next week.
Make sure you like, share, and subscribe so you don't miss anything.
Thanks, guys.